So I'm going to give you some tools today. I'm going to show you what to look out for if you're a juror or if you're being judged by one of these foreign juries, right?
Coercive linguistic strategy, and it's through leading restatement framing.
And one of them is going to be
Testimonial framing manipulation.
Let me explain to you what I mean by this. And not only what do I mean by this, I'm going to demonstrate this for you using, again, the record, the transcripts, things you can go on Pacer, see for yourself. You can evaluate if what I'm saying in this video makes sense. And when you apply it to what you can get in the public record, is it true? You can evaluate this for yourself. Cross-examination techniques
include covertly leading questions
or coercive
restatements
to get the jury to think that things are being said that aren't said. Let me show you how it works. So they're going to try to deploy upon you and your defense team
coercive linguistic strategy.
One of those things is
memory implantation through mischaracterization.
And it's something like a
constructive perjury elicitation.
It's through framing and leading that a skilled prosecutor knows how to draw out the right testimony,
perjurous testimony,
to support his case, even if it's
perjurous testimony.
He does it in a way that creates
plausible deniability
for himself, and he takes
advantage of omissions or
perhaps
ambiguities in the record to accomplish this.
Let me show you how he does this. The prosecutor will try to lead and lay some very suggestive foundation on direct examination of their prosecutorial witness. They call their witness up. They've already
conferred with their witness
in the back room. They've
coached him up.
They've gone over it with them, but now they're on the stand, right? And so they're going to really try to draw out, set the stage. They're trying to
get the witness on the stand to essentially lie. Perjurous testimony.
They're going to
lead, suggest perjurous testimony.
They're going to try and get this testimony
perjurous testimony.
But it's going to have its holes in it. So on cross, defense counsel is going to try to poke holes in the testimony
perjurous testimony.
Draw out those contradictions. And then on redirect, the prosecution then goes in and then will
reframe what was actually said
to that point. And
this will, light bulb will go off in the witness usually, and you'll see perjurous testimony. How statements completely change 180 degrees. Perjurous testimony.
And they both can't be true. And you'll notice the detail and how it shifts and just how fraudulent
perjurous testimony
it really is. And so this is what I'm talking about. Like, it's not like I didn't see this
perjurous testimony
in my trial. I'm being very demonstrative, right? I'm looking at the witness, looking at the jury. I'm like going like this. My hands are in the air. I have a moment to talk with my defense counsel. I'm like, these witnesses are like
perjurous testimony,
clearly lying. And he's like, I'm being told to shut up. We got to let the jury see that. And I'm like, well, the government is like mischaracterizing
perjurous testimony.
What they're saying. Being told to shut up. He's like, well, that's for the jury to determine.
Perjurous testimony.
And I'm like, you're supposed to be my defense counsel. I'm being told to shut up. And while this is going on, again, remember, I'm trying to do anything I can do. I'm thinking, I hope they can see this.
Perjurous testimony.
I'm being reprimanded. I'm being told to shut up. Right? And I'm saying to my lawyer, I'm like, man, Steve, people don't realize what goes on in these federal courtrooms.
It's perjurous testimony.
Let me show you. I like to start at the transcripts in the docket. So criminal docket 10 CR 00326 and go down to doc number 124. That's the transcript, doc 124, yep. Transcript 524, trial transcript from 5/24/2011 in this case. It was redacted. They say they just took out some addresses, personal identifiers. Here's the redacted transcript, document 151. You get this on Pacer, and it's from transcript 124, trial held on 5/24/2011. Okay, so this is document 151, trial transcripts from May 24th, 2011 in case 10326. I'm not sure why this one's not stamped, but this is going to be, they're finishing up direct from this witness, Mr. Nelson, and we're going to go into cross-examination. Now, when we go down to page 16, here's the base question, and it's on line 17.
Do you know he knew there had been representation to the lenders that this would be a primary residence?
Answer.
That I don't know. We didn't remind him to say that prior to closing. But as far as the 1003 or the loan application, I'm not sure if he knew that or not.
23, line 23.
And that was the same for the other unit that he had purchased?
Answer.
Correct.
Now let's go down to page 39. We get down to page 39. We are now on redirect, right, by Mr. McGlaughlin. And we're going to go down to the bottom of 39, line 25. Question.
And I heard you say something on cross. I want to repeat it to you because it contains a pronoun, and I'm looking for the antecedent to the pronoun. You said, quote, we reminded Mark to tell the closer its primary residence, unquote. Do you remember saying that on cross?
Answer.
Yes.
Question.
Who is we?
Answer.
I was told by John to remind Mark that when they asked if you're going to live there, you say yes.
Now, did you or did you not just see a complete 180 contradiction between cross-examination and redirect examination that should raise questions about
witness coaching, mischaracterization of testimony,
suggestibility,
right? Like who's being
promised immunity
here if they say the right. So I think we can analyze all these issues, right, through the lens of forensic linguistics, trial advocacy, and cognitive psychology, right? Particularly where maybe memory suggestibility under duress or perceived threat of prosecution is involved. Real quick, let's just look at it one more time, right? I just showed you in the transcripts on cross-examination, this witness said to a question was,
Do you know if Mark knew there had been a representation to the lenders that this would be a primary residence?
and the answer was,
That I don't know. We didn't remind him to say that prior to closing, but as far as the 1003 loan application, I'm not sure if he knew or not.
that's what he said, right? Now here we are in redirect. Same witness, same day. Just a few minutes later, the prosecutor, lines 25, page 39, and all the way to line 8 on page 40.
I heard you say something on cross.
The prosecutor says,
You said, we reminded Mark to tell the closer it's a primary residence. Do you remember saying that?
answer.
Yes.
Question.
Who is we?
Now he says,
I was told by John. That's right, John. I was told by John to remind Mark that when they ask if you're going to live there, you say yes. Thank you for reminding me of that, Mr. McGlaughlin.
so what did I say? On redirect, there's going to be this reframing to override or overwrite the contradiction, right? It's going to be some type of leading restatement, reframing, a type of coercive linguistic strategy, and it's going to implant a false memory through mischaracterization of the facts. And this is essentially constructive perjury elicitation, is it not? And I'm telling you right now that this isn't, like an outliner. This is the quality of the testimony in the case. This is just a great representation of the quality of the case against me, is just what you saw right there. You saw that the witness, when pressed, right, admitted something.
Look, I don't know if he knew or not. We didn't remind him.
Then the prosecutor restates it falsely, knowingly false, and extracts an agreement from someone who's scared of him. True or false? Now remember, I'm the only one going to trial here, so I'm the only one these witnesses can try to go into court on and say some things and get some time off on, right? And when you think about what just happened here with Mike Nelson, you think about memory suggestibility, right? And under threat of, being implicated in a crime, right? And maybe you've even admitted that you did some wrong, right? So you're going to be highly malleable to suggestion, aren't you? Like the prosecutor kind of holds a lot of your fate in his hands, right? And you're going to agree to a lot of what he says just reflexively, right? To misstatements, just to avoid confrontation with that prosecutor, right? Even to the extent of adopting a new narrative without really even processing the contradiction, right? Here, it's just acquiescence bias, right? You just agree because you're scared not to agree. They say a prosecutor is not just any party to any court case, right? He should be held to even a higher standard. So let's look at this through ethical standards. Now, isn't McGlaughlin's restatement, his whole
Linguistic manipulation strategy?
isn't that really unethical when you think of specifically ethical rules of advocacy? If we look at the Bar Association's ethical rules 3.3 and 4.4, McGlaughlin's restatement and mischaracterization of the witness testimony to elicit
Constructive perjury
is either
a strategic misstatement,
misleading the witness and or jury or a bad faith
reframing of the testimony.
violating ethical standards. Is it not? Now think about this. If you're purposely reframing statements to elicit from some witness who has acquiescence bias, they're scared of you, to elicit a response that you know you're going to get, but you
No, it's false.
I mean, what do you think? I'm just asking questions here, right? You saw the testimony. I showed it to you from the transcripts. I've been showing you a lot of stuff, right? Just coincidental. All this stuff that I'm showing you, it all goes together, right? That's why we always go to the record, the docket. We look at this stuff, try to give you these tools, because if you're on a jury, I want you to point this kind of stuff out when you see it. I want you to point it out. I want you to call it out because it's harmful. People's lives are at stake. And this is the kind of corruption that is masquerading as equal justice under the laws. Let me walk you through this board real quick to really frame up this issue for you, because I want to refer to it in the future. I'm going to call it the Nelson principle because the witness's name was Nelson in this instance, but it is a perfect representation of the entirety of the false perjurous testimony used against me in this false conviction in case 10-00326. So now the issue at hand here is whether or not Mark knew that the loan application contained a representation to the banks that he was going to occupy the property that he was trying to purchase through the loan as his primary residence. And the way they're trying to establish that I knew that this was wrong and that we shouldn't do it is the prosecutor is trying to, at the end of all this, he's trying to tell the jury that I told Mark that he needed to hide this from the lender. So it comes up and it's very vague. So on cross-examination, my attorney is trying to get to the bottom of it, right? And so he asks,
Did you remind Mark or not?
and he clearly says,
We didn't remind him.
so the prosecutor sitting there, right, a couple minutes later gets up and he reframes and creates a false restatement of what was actually said.
Do you remember? You said we reminded Mark to tell.
That's a direct contradiction. Now, also on cross and earlier, it wasn't established whether or not John was involved in telling Mark. And in fact, most of the testimony is,
Mike dealt with Mark.
but cross it wasn't stated, but it was now inserted on redirect examination, right? Here's my name is being inserted, right? It's already a false direct contradiction, but now they're inserting my name into it to again falsely implicate me
With false perjurous testimony.
And if we look at the epistemic certainty of this witness, right, on his first answer, and you looked at I'll read it for you again. We'll go back to the transcript. Okay, so this is document 151, trial transcripts from May 24th, 2011 in case 10-326. They're finishing up direct from this witness, Mr. Nelson, and we're going to go into cross-examination. Page 16, here's the base question, and it's on line 17.
Do you know he knew there had been representation to the lenders that this would be a primary residence?
Answer.
That I don't know. We didn't remind him to say that prior to closing. But as far as the 1003 or the loan application, I'm not sure if he knew that or not.
23, line 23.
And that was the same for the other unit that he had purchased?
Answer.
Correct.
He's confident, right? In the second answer, he's submissive. Now let's go down to page 39. We get down to page 39 by Mr. McGlaughlin. To the bottom of 39, line 25, question.
And I heard you say something on cross. I want to repeat it to you because it contains a pronoun and I'm looking for the antecedent to the pronoun. You said, quote, we reminded Mark to tell the closer its primary residence, unquote. Do you remember saying that on cross?
Answer.
Yes.
Question.
Who is we?
Answer.
I was told by John to remind Mark that when they asked if you're going to live there, you say yes.
And I would say that's classic sign of suggestibility. But either way, it's clearly false, is it not? So here's the modus operandi, right? The prosecutor's false, perjurous testimony playbook. I'm going to give you the methods right now. Here they are. Now, when you're fabricating evidence in false cases against people, you got to be prepared for some pushback, right? And in this case, on cross-examination, there was some pushback, some factual development on the record. It's the one thing prosecutors fear. And so if you're prepared and you know there's going to be some pushback, you're going to have a tactic, right?
So you got to identify something in that cross. You got to be prepared. There's going to be maybe some contradictions start to come up, because this again is a fabricated false case. So how are we going to hold it together, dot the I's, cross the T's? We got to have some tactics here. So we got to be on the lookout for opportunities to misstate the record and revive our witnesses, kind of smooth over any contradictions that they might have while still furthering our narrative and agenda that the defendant is guilty. And so you got to be prepared to tell it how it really is as a prosecutor. The witness might have said that they didn't do something, but if you need that witness to say that they did something, then you need to reframe it, right? You need to restate it, let them know, with the eyes that they need to agree with this, right? So when they say they didn't do something, you remind them that they in fact said that they did.
And so McGlaughlin, in one of his 150 criminal task force meetings, remember where they all get around, they figure out how to implicate people? They probably have a training on this. I bet McGlaughlin gets up, does a PowerPoint, right? And what he says,
what you want to do here is you want to insert the antecedent. We want to suggest the culpable person, but we don't want it to come off as a statement. We want the witness to stand. So what we'll do is we'll offload this assertion onto the witness just like this.
And who is we?
Now, if you're a witness, right, like the witness here, like
Mike Nelson,
and you haven't been charged yet, you're going to be,
scared of contradicting the prosecutor.
Are you not?
Right.
And in the confusion of what's actually said, right, you're going to have this desire to be cooperative, right? Because again, you're hoping that this guy doesn't charge you. Or if you're like Doles and you're like my co-defendant and they promised you immunity, kind of wink, wink, kind of cat and mouse, we'll put it in our back pocket till you're done testifying and see how it comes out, right? You're going to have a desire
to cooperate.
Are you not? Now, these are the same people, mind you, who I've demonstrated and shown you, like my co-defendant, all the way up till his sentencing, about 13 days before sentencing, he thought that he had
immunity.
Immunity he thought he had, right? The whole time he's testifying against me. Then I've shown you that their expert witness, the one that was going to set the stage for them, this is really a disguised interested party here, right? Because they stand to get a $250,000 judgment if I'm guilty, but that's never told to the jury. Then it's covered up. And then you remember what I said about the actual jury, right? The foreigners, the tourists, the farmers that they brought in to judge me. This is the same people who didn't release transcripts until just a few days ago on July 9th, 2025. So the whole time I'm on appeal. Now think about it here as we look at this. Why would this be? Volume 1, redacted, May 16th, David McGlaughlin. Voir dire examination, Volume 1A, 44, filed under seal. In Volume 1A at pages 44 to 156. 112 pages that we're not allowed to see. And I'm saying that this is an unconstitutional jury. All redacted, everything. It's all top secret. Why would they need to do that? If this was all above board, constitutional, you wouldn't have to do that. Very easy for them to redact some identifiers. They're redacting a lot more than the identifiers because they're hiding something from you. These are the same people who confiscated my evidence and threw me in the hole, transferred me around, right? Same people who denied me fair appeals time and time again, right? Same people. So once they know what they're doing is my point. Now, these people who know what they're doing, when they're doing this in court, the way they want to really solidify it is once they get the perjurous admission or statement that they feel like they need to really boost their case, they jump up, they go immediately, they try to switch positions, go somewhere else, create some other controversy, something to leave that alone. They don't want any objection on that. They want to get away from that. They feel like,
oh, that's on the record now. So at least we can refer to it on appeal. We can say that the evidence is overwhelming. We can claim that this witness said this.
This is the kind of trash that they pull. And that's why they couldn't get a perjury conviction against me later on when I denied and, as they said, lied about everything, contradicted every witness they had. Well, that's because they were misstating the record. And so what they do after they elicit this perjurous testimony is they argue to the jury that they proved my guilt with it. And they did this in their closing argument. I like to go to the record. This is Doc 89. Now you're going to see that there's a big difference between Doc 89 and when the final transcript is actually available. This was 6-2-11, right? And this is going to be the closing arguments and the jury instructions. So closing arguments, Doc 89, trial date, June 2nd, 2011. Just remember those dates. Here's a transcript now, filed 6-6-14.
6614.
6614.
Anyway, it's Doc 218, right? And this is redacted version of the July 2nd trial, right? Not available to me. Remember, all this is being kept from me deliberately. Even though I'm saying I need it, I've been thrown in the hole. My legal work's been destroyed and confiscated by staff. Doesn't matter. And they're going to get into their closing arguments. And so I want to go down to the prosecutor's closing argument here. I think it's on page maybe 45 or 44. It's near the end. Here it is. Doc 218, page 49. We're going to go down now to line 14.
I suggest when you're deliberating, take a look at Government Exhibit 24. That's Mark Nelson's loan file for Unit 2. A lot of that was actually prepared by Mike Nelson, but he's part of the conspiracy. It's a work of fiction. Everything in it is a lie. Everything. Why? To get the loan done. To get money out of those Dayton deals. That's the theme of this case.
So let's just walk through some of the psychological linguistic levers at play here. This one is the memory suggestibility. Memory is reconstructive, right? Especially under pressure, and the witness
Can conflate what the prosecutor said
with what they actually said. And then you have that authority compliance component, right? The prosecutor's status and confident restatement creates pressure to agree, especially if the witness fears prosecution. Would you agree with that? And then you have pronoun ambiguity. The use of vague reference like we, they, or someone allows reinterpretation. And then you have false attribution, reattributing prior words to someone else or changing the context
of a quote.
And then you have strategic topic switching, and it's just changing subjects immediately following some new established false narrative. Did you know that studies show that witnesses are susceptible to post-event suggestion, and they're especially susceptible to authority figures? Let me know if you like any of these names for this stuff, right? I'll get some shirts made or something, maybe some tees, some hoodies, some of this stuff on them. But
Narrative implantation.
right? You think McGlaughlin could walk around the office, or prosecutors would buy these if
We direct poisoning.
on it, or some representation,
Framing bias during examination.
or
Constructive falsehood through restated testimony.
right? What if we made some shirts or just some little knickknack or something we could sell prosecutors? Do you think that would work? Now, I hope you read this stuff up on the board, but isn't it always the case that the biggest accuser is a hypocrite? The person calling someone else a liar repeatedly, right? Repeatedly, like in his closing argument, he calls me a liar. He implicates it again by bringing up that false perjurous Mark and Mike Nelson testimony. Then he says that you can't trust me because I can talk the stripes off a zebra. And, just basically his whole theme was that I'm a liar, and he's the liar. He's clearly the liar, and he's completely fine with lying.